Get the testimony of children on and for the record. Forego a custody evaluation. In my previous blog on the subject of child custody evaluations, the link to which I include here, I started a series of videos critiquing custody evaluations. I never saw the value in custody evaluations, but for years I went along with them, either because at the beginning I thought there may be some value to them that I didn't yet perceive in my inexperience, and B, I didn't have a well-defined, well-defended alternative to custody evaluations to propose. Those days are over, at least given the way the custody evaluations are performed now. I now make no secret of being highly disappointed by the intellectual, evidential, and jurisprudential disingenuousness that props up 1. The popularity of child custody evaluations, 2. The way they are performed, meaning the way they are currently performed, and 3. The way they justify accepting or rejecting the custody evaluator's recommendations. As I explained in more detail in my previous video, custody evaluations are obscenely expensive, waste an obscene amount of time, and are evidentially defective. Yet the majority of lawyers and judges still favor custody evaluations and favor them over faster, less expensive, and more reliable forms of evidence. They make many patently lame arguments to support child custody evaluations, at least the way they are being conducted currently. One of the most repeated is this: deposing children, and a deposition is essentially questioning a child under oath like you would in court, just not in the actual courthouse, or having an interview with a judge, risks causing harm to the children, or at least more potential harm than a custody evaluation would ostensibly cause them. Now, if you ask just how deposing children or having them interviewed by a judge risks causing the children harm, the answer you will get is something along the lines of, well, it would involve the children in the custody dispute. But when you ask, and you should ask, how having a custody evaluator interview the children doesn't also involve the children in the custody dispute, you'll get a blank stare, or you'll get one of those, oh, you're just stupid if you can't see the emperor's new clothes kind of response. If you follow up with the question of how a custody evaluator interview is materially any different than having a lawyer or judge interview the children, you'll be told something along the lines of, well, custody evaluators are neutral, but so is a judge. And if the defenders of custody evaluator interviews point out that lawyers for the parents are not neutral and thus somehow disqualified from questioning no one other than the children, you can show how many ways to prevent a lawyer for the parent from abusing the deposition process can be performed, if and only if there is any proof in the first place that the lawyer would do that. By way of just 2 examples, you could have a lawyer for a parent, or both parents, require a list of questions to be asked by the child to be approved by the judge in advance, or if not approved by the judge, approved by the lawyers for both parties in advance, and then submitted to the judge for any tie-breaking or logjam-breaking purposes. You could hire a referee to supervise the deposition. Besides, the very presumption that subjecting children to a custody evaluation does not risk materially harming the children, and being nervous is not harm, lacks proof. Nor is there any credible proof that being questioned by a lawyer and or a judge is inherently harmful to a child in any material way. Face it, admit it. A child who is uncomfortable with talking about child custody issues is going to be uncomfortable with it regardless of whom he discusses it with. There's a vast difference between being uncomfortable and being harmed, and any rational human being knows how to tell the difference. The claim that it's inherently harmful to children for a judge or a lawyer to interview the children for and on the record, but that a custody evaluator makes no verifiable record, somehow does a better job of interviewing the children and doing them less harm, is bunk.